This is Legal Holds in 7 minutes. Someone's going to get the door for me. My name's John Jablonski. I'm an attorney. I'm the author of, amazingly enough, 7 Steps for Legal Holds of ESI and Other Documents, ARMA 2009. So for my background, I've analyzed thousands of litigation hold cases in my spare time, of course, and have developed some rules that are from those various cases. So I'm going to try and teach you the best practices in litigation holds in 7 minutes. Designed to be fun, somewhat interactive, so shout out your questions as we go along. But this is my background slide. We're not going to waste time on that. So what's essential about the legal hold process? You know, what preservation steps can I teach you in 7 minutes is the challenge that I have here. And what is the meaning of reasonable steps, and why is reasonable steps important to me, other than the fact that I have a book that says 7 steps for litigation holds of ESI and other documents. Reasonable steps is, we heard the mention of reasonable steps next door. So we're going to talk about the law, we're going to talk about complying with the law, and then we're going to talk about putting a team together for complying with the law. So from my standpoint, if it wasn't for preservation law in the United States, we wouldn't have a litigation hold process. We wouldn't have e-discovery for the most part. So understanding how the law operates and how it can help you is really important, because from my standpoint as a courtroom litigator, I find that litigation holds often is a game that's played by your opponents. So understanding what tools you need to prove to the court that you've taken reasonable steps is really key and really important to the litigation hold process. So how many people have heard about Federal Rule of Civil Procedure 37E? Who remembers when it was 37F? Okay, we have a couple of people, old timers. So the old law, which was an attempt to help companies stop over-preserving information, failed. That's the bottom line of the old law. It gave a safe harbor that lasted for all of 6 cases, if anyone followed it, because there was some commentary that you had to turn off your auto-delete systems when you were preserving to try and meet the safe harbor requirements of Rule 37E. So that basically wiped out the safe harbor. If you didn't turn off auto-delete, if your left hand didn't know what the right hand was doing and you didn't have systems in place and you chucked ESI out in the garbage, you were in trouble. So this has been a pervasive problem. So I've been involved in trying to get Rule 37E changed for, sadly, about 6 years now. So December 1st, 2015, last year, we have a new Rule 37E, and this provides a real safe harbor for companies that follow the magic words reasonable steps. We're going to talk about what those reasonable steps may be, but if you understand the process, you'll understand how it's now truly a safe harbor. So I put together this decision tree to help you with the new rule. So there's 2 components to the new rule. Under 37E, if you lose stuff that you were supposed to preserve and you replace it, or you followed reasonable steps when you lost it, you can't get sanctioned. But if you follow reasonable steps, or don't follow reasonable steps, I'm sorry, if you don't follow reasonable steps, then the court can order measures, but no greater than to cure a prejudice in the case. If there's intent to deprive, which is the second part of the rule, if there's an intent to deprive in the rule, and we'll go over it in a second, then you're in trouble and you're going to get adverse inference charge or something like that. So with respect to the rule, your first decision point is, should it have been preserved? Do you have a duty to preserve? So those are all the trigger event cases that I'm sure some of you are aware of. If you didn't have a duty to preserve it, if it wasn't relevant to the case, another key point, if something's not relevant to the case, meaning it hasn't been demanded as part of the complaint, you're not used to it from the past, then it doesn't have to be preserved. So if it doesn't have to be preserved, you're safe. If it should have been preserved, but you took reasonable steps, and you can demonstrate those reasonable steps. You have a litigation hold process, you did custodian interviews, the steps that you need, read the book, you'll find the steps that you need, then you're good. If you, despite reasonable steps, lost the information, you can restore or replace it. And then you're out. So those outs get you out of Rule 37E with respect to a safe harbor. If, unfortunately, you find someone in your organization that has an intent to deprive, then you have to determine whether or not there's been prejudice from the other side. If there's no prejudice and the information can be shown to be not that important to the case, then you're not supposed to be sanctioned either. The court's just supposed to provide measures that are no greater than necessary to cure the prejudice. If there is an intent to deprive, which is a mens rea, something that's often difficult to show, but the court can use the circumstances of the case, the facts and circumstances, to determine if there was an intent to deprive. If there's an intent to deprive, then the court can give that awful adverse inference instruction. They can tell the jury that the information was unfavorable, or they can dismiss your claim if you're the plaintiff, or to grant a default judgment against you if you're the defendant. So what does all that mean? I ran through it very quickly. It's hashtag reasonable steps. So what are reasonable steps? Reasonable steps are what we've been talking about: identifying the trigger event, analyzing the duty, and whether or not you have a duty to preserve information. If there's no duty, then you can stop. You're good. Otherwise, you have to define the scope, which is sort of what I call the law school problem. Then you have to implement your litigation hold. Get it to your custodians, make sure that they acknowledge receipt, make sure that they understand their duty, and then what I call enforce and examine, which is you basically go through steps 4 and 5 through the implementation and the enforcement process until you're satisfied that everyone that should be preserving information, including your IT department, is preserving information. As the case goes along, you modify as necessary. A new demand comes in your case. You've never seen a request for this information before, then you go ahead and modify, then you monitor, and then you remove. So what does that mean? You can do it. I'm over my time, but let's talk about it for 30 seconds. Process, people, repeat, audit, and improve. If you paid any attention to what I was saying and you implement all of these things, you will be protected by the safe harbor, and you will have reasonable steps, and you will live happy and long, prosperous lives at your organization. Thank you.